Good evening and good afternoon in Uruguay, in UK, and wherever actually you will be watching this match. This is a match of the quarterfinals of the Inter-University Law Debate Tournament, edition 2023, and my colleague, Namaya Urbanova, will be hosting the match. I'll give the floor.
Good afternoon, good evening, and good day, everyone. It's a pleasure to welcome you to the second match of quarterfinals of the Hague Inter-University Law Debate Tournament 2023 on behalf of Corex Foundation, who is the organizer. Welcome to the debate teams of University of Manchester and the debate team of University of Republic of connecting from Uruguay. The two teams have received the debate statement 7 days in advance. The debate statement for today's session is as follows. Employers should have access to health data collected by their employees' wearable smart devices. The two teams have prepared for both sides of the argument. In a short while, we will know which position will be with which team. But now it's time for the students to introduce themselves, starting with Mr. Adam Beach of the University of Manchester. The floor is yours.
Hello, I'm Adam from the University of Manchester. I'm a second year law with criminology student and really excited to be here today. Really looking forward to hearing our opponents' arguments and their debate.
Welcome. Joining us from Uruguay, Mr. Ignacio Michelini.
Well, hi everyone, it's a pleasure to be here. My name is Ignacio Michelini, I'm 21 years old. I'm a fourth grade student from the University of the Republic Law School.
Welcome. I'll give the floor back to you, United Kingdom, University of Manchester, Miss Diana Panate.
My name is Diana. I'm a second year law with politics student at the University of Manchester. And once again, I'm thrilled to have this debate and hear out your speeches today. Thank you.
Welcome. From University of Republic, joining us, Ms. Maria Federica Sainz.
Hi, I'm Maria Federica. I'm a third year law student. I'm from the Republic of Uruguay, and it's also a pleasure being here.
Welcome. And joining us again from University of Manchester, Ms. Amale Labida.
Hello, my name is Emel. I'm a second year law student at the University of Manchester. And like my teammates, I'm very happy to be here and I'm excited to see what this debate brings.
Welcome. Let me just reiterate at the very beginning, the two teams have passed the group phase and also their first matches in 8 finals earlier, taking place just about the end of April. So my colleague will share his screen shortly with the allocation of positions. I want to congratulate the two teams on their performance so far and wish you all best of luck.
So yeah, so now we'll know which position we'll defend for this match. So I will share my screen. So already on YouTube they can see the wheel, but you will see as well in WebEx for the allocation of the positions in favor or against. So normally you should see the wheel now with the name of your universities. You can be in favor, you can be against the motion for the University of Manchester or the University of the Republic. So we'll click in the center and we will know which position you will defend for this match as the team in favor will start the match. So this is the University of the Republic who will be defending the position against the motion, and as a consequence, that would be the University of Manchester will defend the position in favor. So concretely, it means that the University of Manchester will be starting the match and will be defending the position that employers should have access to health data collected by their employees' wearable smart device, while the University of the Republic will defend the position that employers should not have access to health data collected by their employees' wearable smart device. So now you will have 5 minutes to review your notes and prepare for the match, and we'll hear, of course, the position in favor, starting with the introduction in 5 minutes. Yeah.
Thank you very much. Your time for final preparation is now over. We'll be starting with the position in favor. So the debate team from Manchester, you now have 4 minutes for your opening statement whenever you're ready.
Yes, thank you. I'll start in 1 moment.
Just for clarification, the timer always goes with the first sound of your opening statement.
Dear colleagues, esteemed judges, and distinguished members of the public, I stand before you today to advocate for employers' access to health data collected by their employees' wearable smart devices. Our case will be divided into 3 sections. Firstly, I will discuss the legislative framework we have in place and emphasize the importance of informed consent over data use. Secondly, my colleague Adam will explain the benefits of using health data for occupational health and safety. Thirdly, and lastly, my colleague Amal will explore the opportunity to secure better health insurance conditions. To begin, allow me to clarify that we do not want to allow employers unlimited access to employee health data. We want to introduce this motion with respect for the protection of employee data, emphasizing the importance of informed consent. The General Data Protection Regulation in the EU and the International Labour Organization's Convention on the Protector of Workers' Personal Data, Article 5 to be more specific, set out principles for processing workers' personal data as individuals. It requires that the data collected for specified, explicit, and legitimate purposes, criminalizing, therefore, unconsented illicit use. Article 5 of the African Union Convention on Cybersecurity and Personal Data for Personal Data Protection further outline the rights of data subjects, including the right to access, correct their data, right to object to the processing of their data, and right to request the erasure of their data in certain circumstances at any time. Now, employers must comply with all legal and regulatory frameworks when collecting and processing this health data from wearable devices. Failure to obtain informed and expressed consent from employees before collecting and using their health data will result in legal liability. Employers must ensure that collected data are not excessive nor irrelevant for the purposes of their workplace wellness program. It is important to note that the European Court of Human Rights has held that the collection and use of this personal data without the individual's informed and expressed consent violates their right to privacy under Article 8 of the European Human Rights Convention. I would like to draw attention to the 2018 Vitality Program of John Hancock Company, which was, in fact, successful in incentivizing individuals to lead healthier lifestyles while using wearable devices that track physical activities. Employers could therefore consider using Vitality as a blueprint for implementing new workplace wellness programs. This way, they will better understand what the needs of their employees are and how to better ensure their well-being at workplace. Now, allow me to now draw a conclusion. We will conclude that the use of health data collected by wearable devices in the workplace is a legitimate and beneficial practice, as we will further prove throughout our case, and approached in compliance with the current legal framework and ethical principles we now have at hand and can definitely access and respect, employers will be able to collect this data fairly and therefore contribute to a better work environment. Employers will have to ensure that the data collection and the use of their employees' data is fair, once again, reasonable and non-intrusive, respecting employees' autonomy and privacy, most importantly, in the use of wearable technology. By doing so, employers can create a culture of trust and respect that benefits both the employer and the employee. Thank you.
Thank you very much. Now for the position against the debate team from University of Republic, you have 4 minutes for your opening statement.
Thank you. The question we should be asking ourselves in this debate is, if employees give this sensitive data to employers, how much vulnerable will he or she become? I want you to imagine to be in the recognized TV program Big Brother. This means being controlled all the time. This is the case that we are discussing. Even though the wearable devices won't have the capacity to see you or to hear you like Big Brother. It will be like having a little Big Brother on your wrist, because the employer will have access to your heart rate, your breathing frequency, how much steps you take, how much time sit you spend, if you drink water, and other information that as we give, we have to ask, why does the employer need this information? Technology advances at leaps and bounds, and this cannot be stopped. However, human beings should not mortgage the fundamental rights and guarantees that it has won over years for the promise of an eventual better future. There is no doubt that the right of privacy is the one that is most threatened in information society, where data is the price to be paid in the name of progress, leaving behind all the distress and the historical sacrifices that have to be done in order for this right to be consecrated in legislative norms, such as the Declaration of Human Rights, the Civil and Political Pact, and the European Convention on Human Rights. This requires a critical view. The relationship between employees and employers is characterized by inequity. The power of surveillance comes directly from the laboral contract. However, this contract should never be a legit title to constrain fundamental rights that the worker has as a citizen, because even if the worker is settled in a private organization, he never loses the quality of citizen. And even though these measures are alleged to be taken in order to create a safer working environment, the truth is that data treatment has restrictions, such as Article 88 of the General Data Protection Regulation, the one that aims to legislate in the context of the working employment. And it says that it should only be for the purpose of work, and it should not go against the dignity of workers, their interests and their rights. Also, if this was not enough, Article 5 of the same treaty says that introduces the principle of proportionality. This means that it should only be used when there's no other alternative. So to show this case, we're going to introduce a paradigmatic case of the Spain jurisprudence, the Toya case, casino case. There was a case that was introduced. A lot of workers denounced that the right of privacy was being violated. And although the first tribunal rejected this denounce, falling into the terrible mistake of understanding the right of privacy as indivisible, because it said that the right of privacy should only be exercised in the personal sphere of workers. A superior tribunal decided, by the use of this principle, to adopt this sentence, and this was a precedent in order to constrain the power of businessmen, and this should be taken into consideration. Thank you very much.
Thank you very much. This now concludes the opening statements. We are now proceeding to the first rebuttal. The debate team in favor from the University of Manchester, you have 2 minutes.
Hello. Firstly, I would like to address our esteemed opponent's arguments regarding surveillance state, infringing on rights, and why we need employers' access to personal health data. Firstly, I'd like to talk about the surveillance state and the inability to infringe on rights. What we're advocating for is employees consenting to this. And furthermore, GDP Article 6 actually provides circumstances where processing of personal data can be lawful, even without consent. Article 6.4 says processing is necessary in order to protect the vital interests of the data subject or of another natural person. One of these vital interests is their health. So by granting employers access to health data collected by their employees' wearable smart devices, employers can fulfill their legal obligation. Firstly, business enterprises have a responsibility to exercise human rights due diligence, as articulated in the UN's guiding principle on business and human rights. The UN Declaration of Human Rights, Article 25, states that everyone has the right to a standard of living adequate for their health and well-being, including medical care. If employers have access to employees' health data, they can exercise corporate due diligence and identify and provide medical care to employees who need it. upholding this human right at a higher standard. Additionally, the Occupational Safety and Health Act in the US requires employers to provide a workplace free from hazards that are likely to cause death or serious physical harm. By allowing access to employees' wearable smart devices, they can fulfill this obligation more efficiently. This is because wearable smart devices are exceptional at assessing potential hazards and health risks and preventing death or serious harm. There are many examples of when wearable smart devices can and do save lives. If employers had access to this, workplace accidents could decrease drastically. Lastly, Article 5 of the European Economic Communities Directive on Occupational Safety and Health requires employees to ensure the health and safety of workers in every aspect related to their work. This includes psychological issues too. By accessing employees' smart devices, employers can track things like stress, anxiety, and sleep. This will allow employers to implement more effective strategies so they can look after their employees' mental and physical health much better, resulting in a safer, happier, and healthier working environment for employees and employees. Thank you.
Thank you very much. For your first rebuttal, the debate team from the University of Republic, you have 2 minutes.
Well, thank you. We agree with your team on that the fact that there is a legal framework on protection of personal data, but we cannot forget that we are talking on wearable smart devices, which the reality indicates that the reality is different, because humanity has the need of protecting personal data, which is a human right, which it protects not the data itself, but the people. And in this sense, there is a concern about data abuse. There are no, and the problem here is that there are no uniform standards for collecting this data or reporting it. It's all over the map, and there's not yet a consistent mechanism that can be used to aggregate data and reliably use it in wide-scale privacy-protect analytic scenarios that could prove or refute this hypothesis that we are debating. And in this sense, it is clear that employers having access to this kind of information, which is not only per se intrusive, but also opens the door to an abusive use of this information. While it can, for example, stimulate the employer to start dictating private life aspects of their employees, which should be the most important thing to take into consider how this employee develops or performs in the work sphere, not in their private life. So the question here we should be debating is why? Why should the employer be aware of how much employees sit, eat, drink, sleep, or go to the bathroom? We cannot conceive any hypothesis in which this is necessary and also fulfills the requisites of the proportionality test. And even though if such situation exists, it would be no more than an exception to a rule which is aligned with the right of privacy, human right privacy, which is clear. Employers should not have access to employee private data, including, of course, health data collected by wearable smart devices. Thank you.
Thank you very much. For the second rebuttal, debate team of University of Manchester, you have 2 minutes.
Esteemed colleagues and judges, I would first like to address the arguments that have been made by the opposition in last speech. And a concern that has been articulated is the fact that the data might be misused, but the opposition has also highlighted the reason why this may occur in the first place, and that is that we currently do not have a legal framework which we follow for data collection. But our first speaker already articulated that we could follow the John Hancock Life Insurance Company model, which would prevent any misuse of data collection. I would now like to move on to my substantive, where I will discuss the healthcare benefits that the passing of today's motion will yield. Employers are well equipped at enhancing the provision of healthcare services for 2 reasons. Firstly, healthcare tracking would allow them to implement preventative measures. And secondly, they are able to negotiate better health insurance deals. Health tracking data can be used to identify employers who are at risk of certain work hazards in riskier jobs such as coal mining or construction work, whose health is often put on the line during their work. If a group of workers all show the same trends of respiratory decline, for example, an employer might look into the air quality at the workplace. Accessing health data collected by wearable devices would therefore help employers identify trends and would allow the implementation of preventative measures. The WHO strategy on occupational health for all recognizes that workplaces can have a significant impact on the health of and the well-being of their workers, and that the prevention of occupational diseases and injuries is critical. Accessing health data collected by wearable devices can therefore help to comply with these norms. Now, returning to my second point, health tracking at work can provide valuable data that can be used to enhance health insurance conditions for employees. By collecting data on employee health and wellness, insurance providers have access to data on employees' daily physical activity, and they can use this information to incentivize healthier behaviors. They could also offer, and often do offer, corporate discounts and rewards to employees who reach certain fitness goals or participate in wellness programs. Health tracking can help to create a more proactive approach to healthcare, where insurers and employers work together to prevent health issues rather than simply treating them before they occur. Thank you.
Thank you. For the second rebuttal, debate team of the University of Republic, you have 2 minutes.
For what's being said, this measure seems to be much more, it seems to help much more the employer than the employee. That is the one who is giving away his information and whose right of privacy is being threatened for the community of employers who have the responsibility of creating these safety environments and that are deciding to use technology to escape this responsibility. Furthermore, the opposition argued about the importance of consent, and we would like to ask a question, and that is, how much freedom of choice and capability of negotiation do workers or people who are trying to get hired have towards their employers? None, because the importance and the angular thing of this issue is that these wearable devices are going to be inserted in relationships of inequity, and giving the employer more power towards their employees is completely harmful. It could derivate in different problems such as fires because of discrimination and other circumstances that we must attend. In his work, Ian Weinstein, Freedom and Privacy, he expanded in the importance of that individuals have to decide who, when, and to what extent information is going to be used. And this is something that we must take into consideration. We will not let workers pay with their rights things that should be taken into consideration from the employers. Thank you very much.
Thank you very much. This now marks the end of rebuttal and start of conclusion. The debate team from University of Manchester, you have 2 minutes.
For the last time today, I have the pleasure to deliver our team's reply speech. Throughout this debate, the proposition has provided complex, well-argued reasons for which the benefits of voting in favor of this motion outweigh any potential negatives. These negatives which can easily be regulated. Now, we have established that we already have the appropriate legal framework in place and have emphasized the importance of obtaining informed consent. Then we have proved that by granting employers access to healthcare data by wearable devices, we will support and strengthen the employer's legal obligation to ensure the safety and health of their workers, and we will allow employees to be understood better and to have been given more suitable needs for their health. Now, lastly, we explained that employers are well equipped to enhance this provision of healthcare services by using this health tracking identification trends. And also, it will help them assess preventively risks in the workforce. Now, allow me to touch on 3 points that opposition has made today. Firstly, they have mentioned that, well, employees will be more vulnerable and that also that we will, by implementing this motion, constrain their fundamental rights. Allow us to once again emphasize the importance of the fundamental right to privacy that we do not, that we highly respect, because once again, we would like to remind you that we would not oblige anyone to consent to this. This is a voluntary choice that the employees can have or can reject. Secondly, they have mentioned the concern for how data will be used. As we have mentioned, the John Hancock example. We believe that, furthermore, legislation and technology allows us to ensure high levels of security, of privacy, and furthermore, we cannot use any data for other purposes than the ones that employees have consented to. Now, lastly, negotiation capacities. Once again, allow me to remind you that we do not take away any rights or any decisions from employees. We only give them a choice to better healthcare and a better work environment. Thank you.
Thank you very much. University of Republic's debate team, you have 2 minutes for your conclusion.
Thank you. The most important thing or the key element that we must take into that we must bear in mind in order to address the topic of this debate, I mean, what should be the center of attention is right to privacy, which is a human right with all its implications, and to which allowing employer access to health data collected by employees' wearables would be a direct and unfounded detriment of the right to privacy. In this sense, humanity cannot dump guarantees and rights won in the past, which were earned through history by employees, looking for a false promise or a mere illusion of a better future. And why are we talking about a mere illusion? Mainly because of three arguments. In first place, consent. Is there a freedom of choice, really? Can the employee freely decide whether or not allow access when his livelihood depends on it? It is clear that not. And second place, benefits are not game-changing. In this sense, and in those cases in which in fact they are, I mean when employers' access is more beneficial than harmful, are no more than exceptions. And last but not least, in third place, data abuse is inevitable. There is already a business built around health data, and there are no reasons to conclude that in the discussed matter, in the discussed hypothesis, things are going to be any different. We all know for sure that at this precise moment, data which is being generated while we are debating is being stored in databases and to be sold, but we don't even have a clue of who sells it, to who, and to what. Ever be, as technology goes faster and faster than we ever could imagine sometime. So once the door is open for data manipulation, uncertainty is the winner of the show. Thank you very much.
Thank you very much. This now marks the end of conclusions. Just for good ordinance, the moment where the debate team from Uruguay was frozen, the timer was paused as well. Right. So well done to both teams. Congratulations on your quarterfinals match. Congratulations on getting the quarterfinals as well and on your performance so far. I trust that you had a good time, also an interesting time researching the topics. You can now take a breather, sip of water, I'll do a bit of filler, and then we do a typical feedback session with everyone on the call. There's a few more questions just because it's a quarterfinals to add. But let me first start with the debate team from University of Manchester. Ms. Panaid, how did you find the match? Did you perhaps already encounter this in your studies? So what did you think of the quarterfinals?
Well, I'll begin by saying this was an unbelievably fun debate once again, and it was a pleasure debating you guys. Some of your points were actually part of our opposition case, obviously. Yet, no, we haven't studied this specific niche of law in university, but it was definitely very exciting to explore and gave us a lot of food for thought, especially the fact that all of us, personally being rather leaning towards opposition, it was very exciting to try to argue in favor of it. So it was a lovely challenge. And yes, once again, thank you for your time and congratulations to you guys as well.
Thank you very much. And on that note, passing to University of Republic, Mr. Michelini, we already heard that the other team already found some arguments they might have prepared themselves. What about your team? Did you hear some of your arguments?
Yes, what happened to the University of Manchester's team is exactly the same thing that happened to us, but in the other position. It was a extremely great debate. I think we all enjoyed this pretty much, and it was a extremely challenging topic because when preparing this debate, I found a statistic that said that in the United States, the 20% of the population only uses these technologies, for example, smartwatches or these wearable devices technology. So even though if we may have studied in law school data protection, specifically related to wearable smart devices, we haven't thought about it until preparing this debate. So it was really challenging because it's a really new topic. So it was challenging.
Thank you very much. From University of Manchester, Miss Elabida, did you how was the quarterfinals for you? Did you already encounter this topic in your studies, or was it a completely new area, perhaps?
I definitely think this route that the motion took was very niche. I've done some research in the past on like whether or not it would be fine for companies to collect information such as personality tests from employees, but taking it to the extent of like wearable devices is not something I've encountered before. So it definitely did make the research process for this debate very interesting. And I thank the organizing team for coming up with these motions, because again, these are not topics that we would usually encounter throughout law school. So it does really widen like the horizons of our knowledge. Yeah, very interesting. Thank you.
Thank you very much. I must add one thing that I'm unfortunately missed at the beginning is that this round, quarterfinals, actually has a guarantor, and that is Professor Dr. Maria Foldish, who proposed the debate statements for this round. Of course, the topics were assigned at random to the teams from the available ones submitted, but it's the first time we have a fully guaranteed quarterfinal by one of our, I would say, good partners for the organization. Right, so large thank you to Professor Foldish. And returning to the University of Republic, Ms. Sands, how did you find the match? What did you think of quarterfinals? Did you perhaps already encounter this topic before?
I have never encountered this topic before. I am very distant from wearable technology. I don't possess one, but yes, I mean, it was hard like to mentalize yourself and to understand the extent of the statement, because you have a lot of rights. You had like privacy rights, you had health rights, you had technological rights and laboral rights. So it was kind of difficult, but also I think that this is the magic of these debates, because it takes you completely out of your comfort zone. And it was a pleasure debating with the British team, and you are excellent guys. And well, we are very pleased with my partner to be part of this experience, and we want to thank you a lot.
Thank you very much. Mr. Beach from University of Manchester, how did you find the quarterfinals? What did you think about the topic, the arguments?
I found the sorry about that feedback, but I found the quarterfinals very fun, very entertaining. I've never encountered this topic before, or actually anything like this topic either. I found the question a bit challenging, especially since we were arguing in favor. As our opponents mentioned, it sounds kind of like a Big Brother surveillance state type thing, so it was a bit hard to argue for it. But I think it's always interesting when you get dealt those motions, because you have to look at it at a different angle and like look at it in a different way. But all respect to our opponents, they did so well today.
Thank you very much. And very good transition actually to a new question that we would be asking since we are in quarterfinals now. This is an open question. Feel free to take a point to answer. How did you find the experience in the competition this year? Did you have a chance to not only perhaps encounter new topics? We have heard quite a few have been variations perhaps of what you have studied or completely new topics. How did you consider perhaps your journey through the quarterfinals? To the quarterfinals.
Apologies. I, for one, believe it was an unbelievable learning experience because we actually took public international law this semester, to be quite exact. And to be quite fair, the way we managed to immerse and understand legal concepts and bits of international law in our research for these debates was completely different to learning about it in lectures or in law school in general. And it was definitely a unique experience to immerse ourselves into this capacity of understanding new legal concepts from scratch. And also, on another hand, it was a great way to kind of develop our team working skills and communication skills, because we've come a long way from our first debate and the way we prepared for that one onto this one.
Thank you very much. Just a side note before the other team members take note, but for whoever's watching and also for our honorable judges, it's the first time the two teams are participating in the competition. Well done.
Yes, I believe that for my partner and I, it is something, a very moving experience because we share the meaning that is to be representing our country in our academic case of studies. And we believe that this was something that we didn't imagine going so far. And I think that this is a very good opportunity to say how thankful we are with our university, and to thank you for generating this platform that gives you the chance of communicating and debating with people from other countries. And I don't know, I think that it's very moving for us. Yes.
Yeah. Before I forget, we didn't want to pass by the opportunity to thank some our law school teachers and professors which have collaborated in the preparing of this debate. First place to Professor Pablo Schiavi and also to the Labor Law Institute, to his director Alejandro Castelo, and especially to Bruno Sande, Amalia de la Riva, and Sandra Wolfus, which have collaborated in great manner in order to have helped us in order to prepare this topic.
And also Alejandro Castelo.
Yes, of course.
Right. Thank you very much. It's always good to hear that the teamwork, the connections, and the growing of understanding of law is improving, and we hope that it inspires you, and looking forward to wherever the next steps to take you. Right. On that note, passing the floor to my colleague for a traditional conclusion of the round.
Yes, so now we move to the last part, means a bit of networking, and as we are at the quarterfinals, now I would not only ask about your possible connection with the country, but as well maybe some advice that we should know about your country, your city as well, for visiting. I mean, for the other team to visit or for us to visit as well. So, Miss Panite, what could you tell me concerning Manchester that we should all see, particularly the students from Uruguay, in case they come to visit Manchester? And as well, do you have any friends who are from Uruguay or South America in general?
Well, I'm trying to think of something iconic of Manchester that I should tell you guys about, because I've actually moved here 2 years ago because I'm originally from Romania. But I think one of the most interesting things about Manchester is the people, because I feel like most Mancunians have a very interesting passion that they hold for everything they believe in. Everything they believe in, they argue for to the moon and back. So definitely, if you ever visit here, you will feel the same way. Now, I unfortunately don't have friends in Uruguay, but why not see this as a chance to, make some? However, I would love to visit South America. It would be unbelievable, and I hope it's going to happen at some point throughout my life. And if I'll pass by Uruguay, I'll let you guys know. So
Okay.
thank you once again for everything.
Thank you very much. Mr. Michelini, what should we see if we come to Uruguay? For example, if the students from Manchester come to Uruguay, what would you like them to see in Montevideo or in your country in general? And as well, do you have any friends who are in Manchester or in UK in general?
Well, to the first question, there's many things to see in not only Montevideo, which is where we live, and it's a beautiful city, but also in the whole country. Uruguay has nature, has beaches. Also, Montevideo it's a great city. Well, there's Punta del Este, which is really nice. So I recommend you if you happen to be here in Uruguay to visit that, to go by those places, which are great. And no, I'm the same situation as Diana Panay commented. So yes, why don't see this as a chance to have friends in Manchester?
Yes, okay. It's an occasion, of course, to exchange your contact details eventually, or to see connections between the two universities, if it's not yet done, of course. Mr. Beach, do you have any friends from Uruguay? And what could you recommend that we should see, or we should visit, or we should eat, maybe even in Manchester?
I don't know anyone from Uruguay, actually, and I've never been myself. Unfortunately, I'd really love to go at some point in my life when I have the money or time, or both. Something about Manchester you should know. It rains here quite a lot, like a lot. Like, I know there's a common conception of the UK raining a lot, but Manchester rains even more than the rest of the UK. So, I mean, that's not a great thing, but it's something you should know. Yeah, that's about it.
Okay, thank you very much. Miss Sanz, in Uruguay, what do you recommend us to eat or to visit? And do you have any friends in Manchester already?
I don't have any friends in Manchester, but I'm open to. And you totally need to eat our meat here.
Yes.
Unless you're a vegetarian, we respect you. And I think that also you should have the chance to try mate.
Oh, yeah.
I think that you cannot leave this country without drinking mate.
Okay, so yeah.
Fortunately, we don't have one near, but
Yes.
we could show.
We
Yes.
cannot show you.
I've seen many people who carry mate, I mean, everywhere. I mean, you can carry it the whole day, right?
Yes, of course.
Yes, it gives you strength.
Okay, and there is a very special way to prepare it as well. You have to, no? It takes a whole technique.
Whatever meat we can teach you.
Okay,
Yeah.
okay.
Was,
Yes, so as an
correct me
invitation.
if I'm wrong, was mate the tea kind of thingy that you pour water into directly?
Yes.
Yes.
I think so.
Yes, it's
Okay.
kind of stimulant. How do you say it? It's a stimulant drink. It's it has nothing to do with coffee. I mean, it's not similar, but in the effects, it's kind of.
It's a drink. It's a very sociable drink. Like
Yes, you
here
can.
in
Yes.
your university, we are like everyone like is giving mate to another, and I think that the best conversations happen with
Yes.
mate.
Yes, it applies. Let's drink a coffee. Let's drink a mate. It's like the same thing.
We love that.
That sounds really nice. Noted. Thank you.
So maybe you should partner with the main companies who make mate in Uruguay for the organization. So something to think about. Miss Alabida, maybe you have some friends in South America, in Uruguay, or as well, could you, I would say, advise something to do or to see in Manchester, in the region?
I don't have any friends in Uruguay right now, but I had a friend who did a year abroad there, and they said they really liked it. But I haven't been. But I'd love to go. Manchester, I think something that I didn't grow up here, but there's a lot of drag shows, and I haven't lived in another city where there was this many drag shows. So if you do come to Manchester, I'd go to a drag show. Yeah, that's my recommendation.
Okay, so let's go, of course. So that's the end of this session. I have to say, for all of you, congratulations again for everything you have done until so far. I mean, this was a great match to watch and to as well enjoy, of course. So just what comes soon, in 2-3 days, you will receive the result of this match. Obviously, the winner of this match will meet another winner of quarterfinals. That will be around next week. And as well, you will receive some information during the next days concerning the next step and as well, of course, the final week, in case some of you would like to come to attend the match as participants or as well in the audience, because we'll have some activities around the final as well, visits of some institutions, for example. In any case, we want to tell again to the audience in this session as well that the final match, even if it could be some persons in person, it will be live streamed on YouTube as well. I mean, all the matches are live streamed on YouTube, including those like the finals, even if it takes place with persons sometimes in the Netherlands as well, those who come to the Netherlands for the final. So maybe a last word to my colleague.
Again, thank you, and I believe all the important items have already been covered. I just want to really congratulate the two teams. Wish you a wonderful continuation of the week, and looking forward to the next steps.
Yes, many thanks Uruguay, and many thanks as well in UK. See you very soon. Thank you.
Bye.
Thank you so much. Bye.
Thank you.
Bye.
Bye-bye.